Thank you and welcome to this final case of the call of the July docket of the Tennessee Court of Criminal Appeals here in Jackson, Tennessee. We've enjoyed the day, but we'll be back tomorrow. Each side has 20 minutes. If you need any time for rebuttal, the appellant may ask to reserve time upon introducing yourself when called upon, and I'll try to help you keep up with the time. Because we're masked and we have done or made great efforts to allow the public, the media, and all interested parties to hear and listen and see our proceedings, I think it's incumbent upon me each and every time we come into the room to introduce the panel of our court, which I'm very proud to sit with because we're wearing masks. Although we have our names right here, that may not show up on YouTube as much as I'd like for it to. So to my left and your right, from Shelby County, Tennessee, Judge Ross Dyer. And on my right and your left, from Shelby County, Tennessee, Judge Camille McMullen. I'm John Everett Williams from right up the road here in Carroll County, Huntington, Tennessee. Please call the next case, Mr. Clerk.
State of Tennessee versus Robert Collier.
And you may stand, but not at the podium. I'm very sorry, Mr. Clerk. You may sit if you'd more prefer. I found it with my age, the farther I get away from my paper, the less I can read my notes. So it's your call. You may stand or you may sit. You will not offend us at all.
Well, thank you, Your Honor. I appreciate that. I think I can stand. If I can remember to put my glasses on, I think I can read what I've got down.
Very well.
I'm Barry Kuhn. I'm an attorney with the Shelby County Public Defender's Office. I represent the appellant Robert Collier. Mr. Collier appealed this case because his probation was revoked. He entered a guilty plea on July the 12th of 2019 to the charges of criminal attempt, aggravated sexual battery, and indecent exposure. And he was sentenced to 7 years, but then on criminal attempt, and 11 months and 29 days on the charge of indecent exposure, and placed on supervised probation in both cases. On August the 26th of 2019, the parole board filed a violation of probation affidavit. And the reason they did so was because he had been arrested at a McDonald's hamburger restaurant in Memphis. And the reason for the arrest was because the probation office claimed that he had violated a provision of the Sexual Offender Registration Act. And the section in question that we're dealing with is section CCA 40-39-211 D1B, which makes it unlawful for a sexual offender, and he's defined as a sexual offender, there's no issue there, makes it unlawful for a sexual offender to stand, sit idly, whether or not the offender is in a vehicle or remain within 1,000 feet of the property line of any playground, and I'm abbreviating some of the statutes, because playground is what we're dealing with here. Playground in the state when children under 18 years of age are present while not having a reason or relationship involving custody or responsibility for a child, or any other specific or legitimate reason for being there. He was at a McDonald's restaurant, and there was an area next to the restaurant, or as part of the restaurant, where children, there were swings and things, apparatus for children to play on. There was a wall with a large plate glass window separating him from the playground. He was inside at a table eating his lunch. Our first argument is that he was not in violation of the statute because he had a specific and legitimate reason for being there. He was there to have lunch. That was why he was there. Whether or not he was there to look at children, there's no proof in the record as to what his intent was. We know he was physically there, seated at a table. There was food in front of him. He was eating it. There was a patron who recognized him as a registered sex offender. Somehow or another, he or she knew him, called the police. The police came. When the police got there, he was seated at the table with the food in front of him, still eating it. And he was placed under arrest. And that's our first argument, that he was there for a legitimate reason. To kind of lead into the next argument, he didn't know whether or not he had violated the statute. And when the police got there, he asked them, have I done anything wrong? They weren't sure. They called another police officer who was the charging officer who came to the scene. And when he got there, he wasn't sure. He had to call his office to find out about what the statute said and to make a decision about whether Mr. Collier was in violation of the statute by being near a playground.
Were there children on the playground, Mr. Coon?
I'm sorry.
Were there children on the playground?
I think there were. Yeah, that's in the record that there were children there at the time. And in fact, and it's not clear from the record, but I would assume, and I think there's some indication that the parents of the children were there at the same time. And I think that's important, and I'll argue about that in a minute. In fact, I think at one time they said that the police officers saw a mother going out of the restaurant with 2 children. Well, that's my first argument. He didn't violate the statute. He was there for a legitimate reason. The second argument is that the statute itself violates the 14th Amendment, because the 14th Amendment of the Constitution requires for criminal statutes to clearly define what would constitute a violation. And this doesn't. I mean, a person going to this McDonald's restaurant could legitimately ask, now I'm going to go to the restaurant for a hamburger and French fries, and that's what I want. There's a place next to it for children to play. Am I going to be in violation? It's not clear from the statute whether or not that's what they mean by playground. There's no definition of playground in this part of the statute. There's a definition in another part, in the first part of the statute, that has to do with where you can live or find a job. And that definition just says that a playground is a public place. They exclude private playgrounds, and this at McDonald's would be a private playground. It's, McDonald's is a private company that owns this property, and this is their playground. And they basically should have a right to conduct business freely, as long as it doesn't endanger anyone. One, he didn't present a danger to any children at the playground there. As I say, the parents were there. The employees were there. There was somebody who was there to call the police because they recognized him as a sex offender. These children were in no danger. And I don't think that's what the statute is designed to do, is just to prevent someone from going to a restaurant and having a meal if there might be children present.
You'd have to admit it's a pretty poor choice.
Well, I will admit that, Your Honor, it was.
I've been watching Gunsmoke when I was a young man. Matt Dillon would tell him he wanted him out of town by sundown. I never did know why they hung around any longer. He was always a better shot and a quicker draw, but they'd always hang around to sundown. This gentleman knows he's a convicted sex offender. Why in the world, what possible reason would he have to sit at a window next door to children playing?
Well, of course, we can't be naive about this. I understand what Your Honor is arguing and what Your Honor is saying. My response is that there's no proof that that's why he was there. He was there, the physical proof is that he was there to eat a meal. And that's why he was at the restaurant, and that's a legitimate reason.
So his defense is he didn't know it was there?
I'm not arguing he didn't know it was there. And I'm not Well, I'm arguing he didn't violate the statute because he had a legitimate reason for being there. Also, I'm arguing that the statute is unconstitutional because it's vague. And there's a case I cited in my brief that says, even though a fact situation may fit comfortably within the statute and it's clear and there's no vagueness with regard to this one particular case, the statute to be constitutional has got to apply to every case and be clear and consistent in every case. And for instance, in this case, forget my client is sitting in a restaurant having a meal, but suppose there's someone who is employed by a company to make repairs, and he's 3 doors down in another building, and he's fixing a door or something like that. If he's a registered sex offender and he's within 1,000 feet, which is 333 yards plus 12 inches, that's 3 and 1/3 football fields. That's how far away under the statute you have to be from a playground if you're a sex offender. That person, over there fixing the building with no intent whatsoever to be around the children is in violation of the statute.
Yeah, but that person is not in the same building and is surely not decided to eat his meal right next to the window where the children are playing. I mean, that's got to come into play at some point. I get your argument about legitimate purpose, and I have a problem. I'll go ahead and with the state's argument, legitimate purpose only deals with family custody issues. I think you're exactly right. The man who's working at the building next door, and that's his job to repair heating and air units, and he's working at the building next door. He's there for legitimate purpose, and I'm not sure he violates the statute because he falls under the, legitimate purposes part.
Mm-hmm.
But your client, you can say eating a meal is a legitimate purpose, but he chose to eat his meal at a McDonald's, and there's more than one McDonald's in Memphis in Shelby County. He chose to eat his meal at a McDonald's in Memphis, right next to the window, right next to the playground.
Those are the facts. I can't change the facts of the case.
That doesn't
Those
seem
are
like
the
a
facts.
legitimate purpose, like your example of the guy fixing the heat and air unit 2 or 3 buildings down.
Well, I know, it's a different case, but let me argue about the statute being overbroad. Suppose you had a statute that says that someone who has been convicted of theft can never go into a department store again and look at the goods on the shelf. Would that be a rational and constitutional statute? No, because we're punishing somebody for what they might do or what they might be thinking. And that's what we have here, I think. Yeah, he was a sex offender, he's a child molester, and he goes over there to have a hamburger so he can look at the kids outside. Is that a little too broad? Can you punish him for what's in his brain? He doesn't present a threat. There are people around, it's broad daylight, it's noon, he's having lunch. Doesn't that statute just go a little too far? Isn't it restricting his liberties unconstitutionally? Is it too broad?
Yeah, but we're not eliminating your client. So using your example, we're not eliminating your client from eating a meal out. We're just saying he doesn't need to be next to a playground eating his lunch, staring at the window, out the window right next to the playground.
Well, I know, but is that really an offense? I mean, staring at children?
Oh, he's lost that.
He's lost.
I'm sorry.
Mm-mm.
The way I understood, and I don't have the language verbatim as you initially read it, Mr. Kuhn, but the way I read that statute is he can't remain around those children. Okay, once children come into play, because of his status as a sex offender, the legislature has deemed it safer for him to leave, and he chose to stay. And that is the problem with this case.
Mm-hmm. Well, I admit that, that's definitely a
And
problem.
don't we also, I mean, we're talking about punishment and this, and what he can and can't do and how it's to protect children, but is there not also a rehabilitative portion to punishment as well? And if that's the case, part of what the statute is trying to say is, hey, you defendant have an issue with this set of circumstances. And in order to rehabilitate yourself, one of the things we're going to try to keep you from doing is putting yourself in that position. Shouldn't someone have some sort of control over whether he is trying to fulfill the rehabilitative process of it as well?
Well, I think so, and I think, ideally, we would want, say, if somebody molests a child, we should never have him around a child again, ever. The only way to do that is to lock him up. My argument is basically, and I understand that he really makes the case difficult because he goes to a restaurant with the kids in next door. But my argument is basically that the statute is so broad that somebody's going to have to go live on a mountaintop somewhere to stay away from children. That's
There are
what they've
plenty
done
of,
under
there
the
are plenty
statute.
of McDonald's in Memphis that don't have playgrounds.
That's true. In fact,
So, I mean, once again, a really, really bad intentional act to sit at the window by the playground. I just don't, the 4 and 5-year-olds of the world know that there are McDonald's with playgrounds. I don't know why he didn't.
Mhm.
It doesn't take a rocket scientist or a big definition in a law book to know the McDonald's with playgrounds and those that aren't. They're very distinguishable from outside. Wendy's doesn't have them. Sonic doesn't have them. I can't even think of any other restaurant right now on the top of my head that's a national chain that has them besides McDonald's. And they don't all have them, but that's where he chose to go.
Mhm. Yeah, I don't know how many McDonald's in the Raleigh area have playgrounds and which ones don't. It's not in the record. It's not, there was no testimony about that. That concludes my argument. I mean, that's the 3 arguments I've got is one, whether or not he violated, second, whether it's the 14th Amendment violation, third, whether it's too broad to be comport with the First Amendment. So I can't think of anything else to say. I'll sit down and be quiet.
Well, you know, we always enjoy your argument. You do the best with what you got.
Thank you.
That's always good.
I appreciate
And that's
that so
very
much.
much a compliment from me to you.
Well, it is, and Your Honor, I remember at a seminar I went to once, and Your Honor said, when you come before the court, you give it to me as hard as you can. That's what I want, and I've always remembered that.
I appreciate it too. I
Thank
sure
you,
do.
Your Honor.
General?
May it please the court, Catherine Decker for the state of Tennessee. There's so much to unpack here, and I'm going to rely on my brief for most of it and just simply reply to the few points that Mr. Kuhn has made today. His first argument is that his client did not violate the statute because he's asking this court to interpret the phrase or any other specific or legitimate reason to include his actions. And so he's asking this court to interpret the statute. And as I've said in my brief, the canons of statutory interpretation apply, and in this case, it's a Latin, e judice generis. The idea here is that this phrase, that's a catch-all phrase, follows specific language concerning the child care duties and obligations. And under this canon of statutory construction, when a general phrase then must be understood to allow for an exception in this case, when the sex offender has similar reasons to be in a prohibited area that are related to legitimate, cognizable responsibilities, duties, or obligations, such as the duties and obligations that he might have in childcare responsibilities. And I'd like to address something that Judge Dyer said, and that is I need to make a correction on my brief. I think it's on page 27. The first time I described this canon of statutory construction, I say that the reason has to be legitimate, cognizable responsibilities. The second time I describe it, I say childcare responsibilities, and that was inadvertent. It should also just say legitimate, cognizable responsibilities. So they don't have to relate to childcare. The point is, if you have legitimate duties and obligations and responsibilities, a legitimate reason to be in that particular place.
So taking the hypothetical we use and even making it closer to home. Guy works for Joe Blow Heating and Air Conditioning Unit or Company. He and his boss get a call to go to McDonald's because their air unit is not working right. Can he go there and work? It's legitimate and cognizable reason, is it not?
I think it is. I would, if that were my client, I would say do not go there. But we can, possibly, we don't have to answer that question in this case, because certainly eating lunch does not fall within the statute. The first step is to say, what does the statute mean? And it means you must have a legitimate, cognizable responsibility or do your obligation that allows you to be in that particular place.
And so you're drawing the line at not necessarily my hypothetical, the guy who has a job who just happens to be there. You're drawing the line at you don't have to eat lunch there.
Well, sure.
You can eat lunch anywhere. You don't have to eat right there next to that window. That is the state's position.
Oh, absolutely. Because he's saying the fact that I'm eating lunch, that's a legitimate reason. That's a legitimate activity.
Okay.
But that's not a legitimate reason for being in that particular place.
That's not a legitimate reason for excusing you from staying away from children.
No, it's a legitimate activity, but so would reading, so would being on the phone. And certainly the statute doesn't allow for you to come up with a legitimate activity and then go and take yourself into a place that clearly you're not supposed to be. That you have to have a legitimate reason for being in that particular place. He could have eaten his...
Much like seeing I hate to argue your case for you. I'm not going to. Go ahead. I'm sorry. You're doing fine. I was thinking about a playground and children everywhere, and there's a snow cone machine right in the middle. It's not legitimate for him to go in and get a snow cone.
No, it's a legitimate activity to eat a snow cone. And that's his argument. I have a legitimate activity, I'm eating lunch. But he doesn't have a legitimate reason for eating lunch in that particular place. He has to have a legitimate, cognizable responsibility, duty, or obligation to be in that particular place. I'm going to turn to the vagueness because I've answered all of his other arguments in my brief. I'm just going to rely on my brief for the rest. On the question of vagueness, he says first, in order to prevail on a constitutional challenge based on vagueness, a plaintiff must establish that there is no clearly a plaintiff who engages in some conduct that is clearly prescribed cannot complain of the vagueness of the law as applied to other people. So he clearly comes within this statute. He says that there's a vagueness as the question of whether this is a playground. There's really not a vagueness. He creates a vagueness by saying that, well, it's questionable, it's ambiguous whether this word playground includes a public playground or just a private playground. It's actually not ambiguous in any way because again, the rules of statutory construction apply here. In a previous subsection, that previous subsection defines playground as playgrounds owned by essentially the public or a not-for-profit organization. That previous subsection also says this definition applies only to this subsection. That alone means it doesn't apply to the next subsection. And also, according to the Welch case and the idea that the legislature, by defining something clearly in one section but not defining it in another, we know that this definition of playground that's limited by its very terms to the first subsection does not apply to this. So he can't claim it does and then claim there's some kind of vagueness, because there's just not a vagueness. And certainly it is not vague as to whether a McDonald's playground specifically designed for children to come and play falls within the statute. He also, this is an argument that he makes in a couple different sections of his brief, so I'll just respond to it and then it can slot into the different sections. He claims that the police were not sure whether the defendant had violated the statute, as if the police thought the wording of the statute were ambiguous. And what he's talking about is that one of the officers, Officer Taylor, who arrived at the scene, testified that he was initially couldn't remember the wording of the statute. It's not that he thought the words were ambiguous. He simply couldn't remember whether this subsection was the subsection that defined playground as playground only owned by the public.
Let me ask this. The only thing that kind of gave me some pause when I read the briefs in this case was the fact that the GPS monitoring was supposed to notify him that he was in a, or maybe you can clarify for me, I'm not certain of this, that he was, there's supposed to be a beep or something to notify him that he was in an improper area. And he was not, or there was some lack of notification based on the GPS system that he was in a place he was not supposed to be.
The way I read that, and that's the probation officer, it wasn't his probation officer, but she was testifying about this, is that I think she was asked whether it does notify them.
Okay.
And she said, no, it actually doesn't. I took that to mean that it's not designed to notify the probationer, that it's designed only to notify the probation officers.
And then was there not a notification in this case?
She didn't get a notification because the GPS, whoever programs into the GPS probably cannot program every single playground in the entire city of Jackson.
So there wasn't a notification, but the trigger here was the parent who recognized him, and that's the only, I guess.
That's the only trigger, but I know that he makes the argument that, well, that his client, that the probationer would have been unsure whether this playground is included because after all, it's not included it's not programmed into the GPS. But first of all, he would never know that.
Okay.
He would never think, I think the statute is ambiguous because this McDonald's at such and such address isn't in, he would never know what's programmed. It doesn't create an ambiguity in his mind. And second of all, he's told when he's put on probation what the law is. It doesn't, the GPS monitor did not inform him as to where he could go. The law did.
On that there was some connection with the GPS testimony that it was somehow supposed to be informing or play some sort of role in, I guess, notification.
Apparently, it does not notify the probationer. It only notifies the probation officer. I'm just going to turn to his overbroad argument. I didn't hear anything today that identified any liberty that had been. I didn't hear any additional liberty interest today, and so I'm just going to rely on my brief for my overbroad argument. And of course, the first argument for overbroad was waived because it was never raised at the probation revocation hearing. And under plain error review, he's not entitled to well, he doesn't even acknowledge that it wasn't raised. He doesn't ask for plain error relief, and he's not entitled to it in any case. And then his second argument, as I've said in my brief, he just hasn't met the requirements for establishing an overbroad challenge.
Thank you, Jenna.
Your Honor, just briefly, one, I think we did argue the overbroad issue in the trial court, and Mr. Cloud's argument starts on the record at volume 4, page 42, and that's where he talks about the That's where he begins his argument, saying that the statute is too broad, that it covers, well, I won't go into all the reasons, it's in the brief, but it's too broad. I guess one thing this case may stand for is that the old mantra that learned in law school is hard cases make bad law. I mean, this is not really a good case to argue about the constitutionality of the statute when you have this man here doing what he was probably doing. But the issue we have is the constitutionality of the statute. And I think that's got to be something that the court looks at regardless of the facts of this case. You got to look at this statute and just determine what facts does it cover? Is it reasonable? How much does a person's liberty is restrained by this statute, and to what degree does it cut off his First Amendment rights of association with other people? So, and there's a good case that I found that I cited in the brief in which the child sex offender was prohibited from going to a family gathering where he could go and see the children that I think his nephew invited him to come and see the children engage in a sporting event. That's the kind of thing that he's just isolated from ever being able to do again. So is the statute, is it a constitutional statute?
Mr. Coon, thank you for both of you for presenting your arguments today. Mr. Coon, you are very nice to go back to Memphis, and you're very respected in the bar there. I just wanted to let you know that the reason we're going late in the evening like we are right now is we're trying new procedures and protocols because of the COVID-19. And in that vein, the lawyers that appear on behalf of the state generally have to drive from Nashville or Memphis to be here.
Mm-hmm.
And so we have scooted the start time later where they don't have to get up at 4 o'clock in the morning, but they don't mind driving a little bit later in the evening.
Yeah.
Please get that word out down in Shelby County if you don't mind. And we're trying our best to do, I said this the last time, I don't wear a mask because I'm afraid of you. You should be afraid of me. We are wearing our mask out of respect of each other.
Yes,
and then very recently, the Madison County governmental authorities have suggested that we wear them, and we're doing that. But if the bar has a better way or think there's a safer way to do it, please get in touch with us. We're having our staff attorneys to contact you directly to confirm appearances and all of that. And we really appreciate the kindness the bar has shown us during this time and promptly being here and working with our new system as good as it can be right now. We're trying to make it better, but we hope there's not any undue hardships on behalf of the state or the defense.
yes, yeah, I sure will, Your Honor. And no, it didn't present any hardship to me at all. Thank you.
Well, it's been a delight to be here today. Thank you both for joining the issues and the arguments that we've given. Would you have anything, Judge McMillan, Judge Ross? Mr. Clerk, it appears that we've concluded the docket. We'll stand adjourned in the morning.